Start. Accordingly, the valuation, though made subsequently, has to be made with reference to the time at which the right arose, which, in the present case, as found by the learned single judge, was on July 5, 1972, when the defendants filed their affidavit seeking leave to buy, or at any rate on October 9, 1972, when they filed their written statement reiterating that request. In a case such as this, where the extent of shares held by the plaintiffs and the defendants is not disputed, the fact that the proceedings continued by reason of the appeal filed by the plaintiffs against the order refusing to allow them to amend their plaint, or for any other reason, was not relevant to the time of accrual of a right arising under Section 3. The fact that a preliminary decree may have to be passed before passing a final decree, and that no such decree has yet been made, is again not relevant on the facts of this case. To the question as to the time of accrual of a right under Section 3. In the circumstances whenever the shares in question in the properties come to be sold to the persons entitled to buy them under Section 3, the price of those shares will have to be determined on the basis of the valuation made with reference to the time of accrual of the right. This, as found by the learned single judge, was the price prevailing in July 1972. Another aspect which can be culled out from the provision of Section 4 of the Partition Act and the decisions as cited and noticed in the preceding paragraphs, that the legislature has clearly vested ample jurisdiction and discretion with the court to determine the valuation of the share and to give such directions as it thinks fit in this regard. Neither the legislature has put any fetters in the discretion of the court in determining the valuation, nor has the legislature put any restrictions regarding the date on which the valuations is to be reckoned. It is also to be kept in mind that in a suit for partition, where each of the parties is the plaintiff and the defendant, and while making a partition of the property, the court has to keep and balance the equities between the parties. Another crucial aspect is that the co-sharer who exercises his right of preemption actually compels the purchaser to make a forced sale. In other words, a valid transaction of sale in favor of stranger purchaser is sought to be disturbed by the intervention of the court at the behest of a co-sharer. Thus, a casual approach to ascertain the valuation of the share would be fraught with danger to cause injustice to any one party. Accordingly, the court has to be very cautious and must adopt an approach filed with care, precision, and objectivity. Illustratively, if a stranger purchaser purchases a share in a family dwelling house and brings in a suit for partition after a long time, and it is only then that the co-sharer can exercise his rights under Section 4 of the Partition Act, and may make an application immediately on the date of filing of his written statement, or may choose to make the offer to purchase the share of the stranger transferee at the time of passing of the preliminary decree, or even at the stage of final decree proceedings. The fact remains that the date of valuation can never be the date of purchase, or the date of institution of the suit, or the date of preliminary decree, but has to be at least the date on which the co-sharer makes the offer and undertakes to buy the share of stranger purchaser, whatever be the stage of the proceedings. There may be another situation where, though the application and undertaking may have been moved by the co-sharer at an early stage, but he does not cooperate in the proceedings, thus causing cooperate in the proceedings delay in disposal of the suit. Then, in such a situation, whether the co-sharer can take the benefit of a lower price prevailing at the time of application through the prices may have escalated by this time the application or the suit is decided. Another situation may arise where after filing of the suit for partition and subsequent to making an application under section 4 of the Partition Act, but there may be certain circumstances which may lead to a sharp rise in the price of the property before the order could be passed, then whether the stranger purchaser can be deprived of such enhancement at the behest of the co-sharer through a compulsive sale in terms of section 4 of the Partition Act if the date of application solely is taken as the